Hi, I'm Ryan Carter, the Metro editor for the San Bernardino Sun. I'm here with Andrew Edwards, our business reporter, who today is writing about, the legalities of marijuana dispensaries. And Andrew, last week there was, I understand that there was an appellate court decision out of a case out of Lake Forest, and you're writing about it, you're reporting on it today, and I just want you to help tell our readers kind of why it matters to us.
Well, the funny thing, I guess, about medical marijuana has been since 1996, when the voters passed Prop 215, is really no authority in the state can really come to an agreement on how legal medical marijuana is. As far as I can figure out in one day's reporting, the 4th District Court of Appeals Division that meets in Santa Ana issued an opinion last week saying cities don't have the power to ban marijuana dispensaries because state law says dispensaries can't exist in the state. I haven't actually read the language of the opinion that came out a few months ago from the Riverside panel, but in our coverage of it, which my colleagues have addressed, it seems, as I said, the exact opposite. Cities do have this power. Of course, this is a city closer to our area, the city of Upland, which actually has its case with a dispensary called G3 Holistic set to go to the California Supreme Court. So basically, two panels, different divisions of the same appellate district, have given very contradictory rulings on what cities can do as it pertains to medical marijuana. So I don't know when the state Supreme Court ruling will be forthcoming.
So Andrew, let me stop you there. I'm sorry. What have cities been doing to? My understanding is they've been trying to get rid of medical marijuana dispensaries in the Inland Empire. Right.
Right. Several cities, Upland is but one, have passed ordinances which say no medical marijuana dispensaries. As far as Upland, as I understand, they use it basically in their zoning laws. It's saying it's not allowed. That's similar to what Lake Forest did, and I don't know if there's some kind of significant difference in the language of their laws, but this is what the 4th District Court of Appeals Division that meets in Santa Ana says cities can't do. Cities have the power to regulate medical marijuana, but since this is something that's been laid out in Prop 215 and subsequent legislation, there's an issue of preemption where cities cannot say no dispensaries whatsoever.
Oh, so wait a minute. So cities. So was the ruling that the ruling out of the Lake Forest case was that cities cannot use zoning
exactly
as a way of getting rid of.
Right. You can't say, by zoning, cities can't exist in our city. Of course, even that case isn't even completely resolved yet, and that the state Supreme Court may say completely otherwise. But at least this court ruling is saying, if you're a city council and you don't want medical marijuana, you cannot use your zoning laws and say this is not a permitted use.
Got it. Andrew, thanks a lot.
You're welcome.